Hi everyone. I hope you're all doing well and had a nice weekend. We're going to get started now in about a minute. Just wait for other people to join, and we'll get started then with the presentations. Thank you. Brilliant. So we might get started, everyone. Thank you so much for joining today. We're really delighted to have you here for this special collaboration between the Centre for Environmental Justice, Community Law Mediation, and BOLD. So my name is Georgina Johnston. I'm the Policy Officer at the Centre for Environmental Justice. I'll just quickly start by introducing Community Law Mediation. So Community Law Mediation, or CLM, is an independent community law centre that was set up 50 years ago as part of the campaign for civil legal aid in Ireland. CLM works to empower people by providing free legal information and advice in the areas of employment, housing, homelessness, social welfare, child and environmental law. We also provide free mediation and conflict coaching as well as education services. Over the years, CLM has adapted and expanded its services in response to changing needs. In 2021, CLM established a Centre for Environmental Justice. This was an acknowledgement of the fact that climate change and other environmental harms were contributing factors to many of the issues that we're presenting at our clinics. So the centre was established to ensure that no person or community is disproportionately impacted by climate change or other environmental harms, and that environmental measures and climate action protect and build equality and social justice. So thank you so much for joining us, and I'm going to pass over to Maureen from BOLD, who will introduce their organisation. Thanks, Maureen. You're on mute there, Maureen, I think. Yeah.
Sorry, my name is Maureen Bassett. I'm a member of the BOLD Climate Action Committee. So we're delighted to be here collaborating with CLM on this webinar advocating for climate justice. So BOLD is a group of older people who are very concerned about the climate crisis and also very committed to climate justice. So in that I suppose in what we try and do then, we try and reach out to more older people to involve more older people in climate action and advocacy. We also try and build relationships with other organisations to extend our reach and to collaborate. So today's webinar is a great example of that, and we're delighted with this. We do quite a bit of peer education. So in other words, they're mainly targeted at older people, but everybody's welcome. And they're sometimes in person workshops. But just this year, we've taken a new approach, and we've had a whole series of healthy aging, healthy planet webinars, a series of 6. Linking health and climate in a very strong way, and we did this in partnership with the Irish Doctors for the Environment. So that was a really wonderful collaboration, and they have just finished in the last week. We're also advocating where we can, so we would do street action, we support other people's street action. We did some work pre-elections. We obviously involved in the climate march, but also the climate lobby that happens each year, organised by Stop Climate Chaos. So we try where we can to be involved in visible action, because I think it's important that older people's perspectives, voices are visible in the whole climate conversation, and particularly that these are taken into account when climate policy is being formulated. So in that light, we also try and input where we can. It's in a modest way to climate submissions, policy submissions. But the relationship building is a very important part of what we've done. So we reach out to older age organizations to engage with more older people. So Age Action, Age Opportunity, Age Active Retired Ireland. And then we're part of the feminist communities for climate justice. That's a very important network. And we're also members of the National Women's Council. So there are others. Obviously, the Irish Office of the Environment was a hugely beneficial partnership and collaboration. So I suppose that's mainly how we try and achieve what we've set out to do. We're delighted to be here today as part of this webinar. Thank you.
Thank you so much, Maureen. It's been brilliant to learn more about Bold, and we're really delighted to be collaborating with you all on this. I'm going to pass over now to our first speaker, which is Justine Schönfeld-Quinn, who is the lawyer at the Centre for Environmental Justice. And Justine is going to speak about using the law to advocate for climate justice. So if you want to try and share your screen there, Justine, and thank you very much.
No, I'll just. Okay. Thanks very much for the introduction, and thanks to everyone for attending. So I'm just going to introduce a little bit further about the Centre for Environmental Justice at Community Law Mediation. So we've been in existence for 5 years, and some of the types of work that we do include policy, communications, advocacy, and also the legal work, which can involve a mix of clinics, which I'll mention briefly, which are providing information to the public directly. It's a free service, and also sometimes legal advocacy files and legal representation files where we act on behalf of people who've come to us, particularly through the clinics. And also we're involved in a number of climate cases in particular at the moment. So that's information about the clinic there. If you'd like to access it, it's a bi-monthly clinic. It is the opportunity to speak with a lawyer about environmental issues and to understand what the legal framework governing them is and what possible steps you can take to remedy them. And those issues include, of course, climate change. So the legal framework in Ireland is one governed by a climate framework law. And these are laws that have been enacted in more than 60 countries. And the first such law was brought out in the United Kingdom, and they set the overall direction of travel for the government in trying to reduce emissions. And they typically have a series of mechanisms that allow for really a whole of government approach and a planned approach to managed energy transition. So the Irish law is quite a strong law. 2 different acts, 2015 and 2021. The National Climate Objective, which is the goal that we're aiming for, which is to have a climate resilient, biodiversity rich, environmentally sustainable and climate neutral economy by 2050. And that's sometimes referred to as our net zero target. And there are some nuances there as to whether our government still understands it as net zero or whether that has shifted in any sense, but it was presented as a net zero target, and I think we shall hold them to that. So the 5 mechanisms under the legislation, you've got carbon budgets, sectoral emission ceilings, so for each sector of the economy, climate action plans, a national long-term climate action strategy, and a national adaptation framework. The law is unusual in that it references international law very specifically. So it references our international obligations under the UN FCCC and under the Paris Agreement. So the big international climate conventions are referenced, as are our duties under European Union law. And the EU legislative framework for climate change is also quite extensive and well developed and forms part of our legal framework as well. So there are a series of statutory duties in the law, and these statutory duties are aimed at the minister and the government, or at ministers of the government for the specific sectors governed by the sectoral emission ceilings, as well as the Section 15 duty, which is a duty on relevant bodies, which are broadly the Freedom of Information Act governed bodies, to act perform their functions in a manner that's consistent with the climate policy framework. Now, Section 15 you may have heard about recently because the government has brought out 3 different legislative acts which aim to disapply in some way Section 15 from various sectors. So, for example, Dublin Airport passenger capacity bill. You've also got the gas legislation and the critical infrastructure legislation. So we see, unfortunately, some backsliding on the behalf of the government, where they, notwithstanding having a strong legal framework, are seeking to disapply an aspect of that framework from key sectors that are emissions intensive. So climate litigation has been one of the tools that's used in conjunction with the framework climate laws to try to keep states on target. So essentially the government brings out a law, and worldwide, many countries having done this, and they set themselves a goal and they set themselves interim steps to reach that goal. A little bit like if you or I said, well, we're going to go to the gym every Tuesday and every Thursday. And what you do, if you really want to be successful about that, is you tell people that that's what you're doing. Maybe you go with a friend, you try to put steps in place to make sure that you'll achieve that goal. So the governments, in bringing out these laws, they knew that the framework existed then for civil society and for the courts to uphold that framework and interpret that framework. And we see that in climate cases. The Urgenda case, which is on the screen here, is a Dutch case, and is perhaps the most famous climate case, and has been a case that has provided a template and an example for many other similar cases around the world. And it's about the extent of climate ambition of the Netherlands at the time. The Dutch legal system differs from our own and has some unique features, and one of those features has been, in this context, the willingness to invoke the duty of care in tort in conjunction with human rights standards. So the Urgenda Foundation case, brought by the Urgenda Foundation, 900 Dutch citizens, arguing that the Dutch government's targets were not ambitious enough, was a successful case that had the effect in practice of leading to more rapid emissions reductions than would otherwise have been the case, and to the courts saying that the standard target that had to be set based on science is higher than the government had sought to implement. So this case influenced litigation in Ireland as well, and you have Climate Case Ireland, which was brought before the Irish Supreme Court by Friends of the Irish Environment. And this case was about the National Mitigation Plan and its level of detail. Was it adequate? And the court concluded that it wasn't, and it lacked specificity. And one of the key findings there is the reference to the idea that any one of us should be able to look at the climate plans and understand, are we on target? Are we choosing measures that are likely to be successful? So there's a public participation aspect to this process, that everybody should be able to participate and have a say and understand, looking at the plans, are we delivering? Are we going to be able to achieve what we've set out to do? Now, Community Law Mediation is representing Friends of the Irish Environment in a subsequent climate case, and this is a challenge to the Climate Action Plan 2023. It bears some similarities to the previous climate case because it's about, is the plan that the state has put forward, is it sufficiently specific? Does it provide a justification or an explanation of how these measures are going to deliver the emissions reductions that were intended and help the state comply with its carbon budgets, its legally binding targets? So the case also relied upon and relies upon litigation in other countries as precedents that are persuasive, that show how other countries applying similar legal frameworks have interpreted, other countries' courts have interpreted the framework and what the obligations of the government are. So there are 2 cases referenced there. They're brought by Friends of the Earth in the United Kingdom, and they're also about climate planning. So this case is on appeal to the Supreme Court and may be decided towards the end of this year or early next year. And you might like to watch out for it. The major development in climate litigation, which I think will be of great interest to all of you, and which you're probably well aware of, is the Klimasignorinen Schweiz case, which is a case brought by an association of elder Swiss women. And this association had a membership that were by a majority over the age of 70. And they were arguing that the Swiss climate framework was not adequate to protect their rights. Now, they litigated all the way up to the Federal Supreme Court in Switzerland, and they were unsuccessful because it was said that they couldn't show that their rights were violated by the effects of climate change. And this is one of the problems that you have in climate litigation, that it affects everybody, and that its effects are also unpredictable. So we know certain effects, things that could injure people, could cause harm, forest fires, so on. It's difficult to say in advance who's especially vulnerable, but there is a great deal of research about different groups who face particular harms, and those include elderly people. And this is based on very, very sound scientific evidence to say that elderly people are at particular risk of the effects of climate change. And we see that very, very tragically in the excess mortality in, for example, Germany and France this summer. They're reporting on the effect of climate change, and people suffer health effects, and it's difficult to trace it back, except looking at excess mortality. Now, the Grand Chamber of the European Court of Human Rights found in this case that states have a duty to provide effective protection, a positive obligation from the adverse effects of climate change. And they found that the margin of appreciation had narrowed. So the range of choices available to states are lesser. And they found critically also that this association had legal standing, even if its members didn't. And that is an absolute break from previous case law and subsequent case law on environmental harms. So climate change is in a unique category where associations can have standing if they meet the tests set in that case. So the obligations on states, the Swiss did not have a carbon budget. States have a duty to enact a legal framework that meets certain criteria to satisfy the finding in this case. And these include having targets and timelines, including having emission reductions pathways, providing evidence to show that the state is on track, due diligence, reliance on best available evidence, and to act in good time. Okay, so this is a very, very critical case. Community Law Mediation is, for the first time in its history as an organization, bringing an action, and this action is a challenge to Climate Action Plan 2024. There are some similarities between this case and Klimasignorinen in that Community Law Mediation is acting in a representative capacity on behalf of the communities that it typically serves. So these are vulnerable groups, minorities, economically disadvantaged groups. And we know from the evidence, including also children and future generations, that these are all groups that are particularly impacted by climate change. Sorry, I'll just try and go back. There are 3 other applicants in the case, and they come from different generations. And this is the intergenerational equity aspect. There's a grandfather, a child, and a youth climate activist. So each of these groups, again, face particular hazards because of our changing climate. The case is different from the previous case I mentioned, brought by Friends of the Irish Environment, in that it is a fundamental rights case. It's a case that relies upon the Constitution of Ireland, the Charter of Fundamental Rights of the EU, the European Convention on Human Rights, and also as an administrative law aspect to it, as well as the EU regulatory framework, which is referred to in the case. So there's, for the first time, a fundamental rights case concerning climate change in Ireland. And this case is currently before the High Court. It will likely get a hearing date at some point in the future, and it will address, I suppose, definitively in Irish law, whether organizations can act in this representative capacity to rely upon fundamental rights, whether climate change for the purposes of Irish law is a human rights issue that raises constitutional concerns, and also the administrative law portions of whether climate action planning was adequate. Now, there have been other cases, and I think you'll start to see a pattern here where every legal fora that can potentially hold states to account is being increasingly called to address the question of what are the legal obligations of states. And the sheer number of cases that have been brought, I think it's something, I've not got the exact number. It's above, I think, 240 or 260 cases worldwide that have reached top courts. On the international plane, the top court is the International Court of Justice. And the International Court of Justice issued an advisory opinion on climate change in 2025. And what they found was that climate change treaties establish binding obligations for states. So states can be held to account with reference to the climate treaties that they've signed. And that these obligations are not limited to those treaties, but stem more broadly from other international treaties and conventions. And there were a huge number of sources of law referenced in this advisory opinion, and they include the UN Convention on the Law of the Sea, for example. So how the case began, it began with students in the Pacific Islands who got together and wanted to do something about climate change. And they managed to get the support of the government of Vanuatu and then other governments of small island states. There was a 6-year campaign, advocacy campaign, leading to a UN General Assembly resolution requesting the court to give this advisory opinion. There were huge number of interventions and representations made to the International Court of Justice in this case. And the questions posed by the General Assembly resolution, I've just given a snapshot of them, not the full detail, but what are the obligations of states under international law and what are the legal consequences of those obligations? So that's the key to this. And the key finding, international climate law refers to this 1.5 degree threshold. They say this is the agreed goal under the Paris Agreement. They clarify the right to healthy environment as being essential to the enjoyment of other human rights. And there's some nuance there. And if you want to read further, it's very recommended on whether that means that there is an independent right at stake or whether this is derived from other rights. So it's a very, there's a very great wealth of literature about this case already and a great deal of discussion about it. The right is a right that every person has to a clean, healthy, and sustainable environment. And this is prerequisite to enjoying other rights. So states can't meet their human rights obligations without protecting the environment. So what has happened? If a state fails to uphold their climate commitments, they're committing an internationally wrongful act. Acts of omission by the state or bodies connected to the state are attributable to the state. And a failure to regulate greenhouse gas emissions, including licensing of fossil fuel extraction, for example, could be an internationally wrongful act. So the state's legal duties stem from a wide variety of sources of international law, climate law, environmental law, customary international law. And this right includes the right to a clean, healthy, and sustainable environment. So the ICJ advisory opinion, what does it mean? It sends a signal from the highest court that climate change is something that triggers state liability. Its impact will work its way through other courts that will reference the case, very similar to Clima Signorenan. What will be the ultimate effect of the Grand Chamber judgment in Clima Signorenan? Well, it will shape how courts across all of the 47 states of the Council of Europe interpret fundamental and constitutional rights-based obligations with regard to climate change, and also how they will address standing. So the impact of these cases is still being felt, and in an Irish context will be clarified by the case brought by Community Law Mediation and others in challenging the Climate Action Plan 2024. It's not the only case that has been brought before an apex court at, so the European Court of Human Rights is not the only apex court that's relevant to us in European countries. It's also the EU courts. So we've got two separate systems that have some interconnectedness. The convention system, of which the European Convention on Human Rights is a part, which is the Council of Europe of 47 states. And we have the EU, which is the 27-country European Union with a Court of Justice. And the Court of Justice has been asked to consider climate cases. One case brought by Climate Action Network, representing 1,700 European climate NGOs and also 10 families, people from across different countries, was brought as what's called an action for annulment. And here we see the difficulty that climate litigation faces. It has to fit within the kind of format that exists for litigation, which is often quite restrictive. The action for annulment in EU law is where you seek to overturn an EU law. You have to have standing, and the legal standing, the ability to take the case, is restricted to people who can show direct and individual concern. And that has been interpreted since the 1970s in a case called Plowman in a very restrictive way, so that you have to show that the law almost is addressed to you. So the case failed on standing grounds, and it has not been possible thus far to have a climate case substantively decided at European Union level, partly because this quite difficult way of reaching the courts. The other opportunity would be through preliminary reference, where a national court refers a question to the European courts. And there is a third way, which is through request for internal review. So I'll just flag that there is a case coming up, which will be decided. The judgment's due to be handed down on the 2nd of September of this year, in which we act for Global Legal Action Network and Climate Action Network Europe. And we will see in that case whether request for internal review process under the Aarhus regulation provides another avenue for accessing the European courts and having them consider climate issues. So I hope that's been given you a flavor of some of the different ways in which climate is being litigated nationally, internationally, before the European Court of Human Rights and also before the EU courts. And yeah, look forward to the discussion. If you'd like to contact me or you'd like to reach out to the Centre for Environmental Justice, the website is there and my email address is on screen. You can also reach out through the info account as well. Thanks very much.
Thanks so much, Justine. That was a really comprehensive overview of climate litigation and its role in advocating for climate justice. I am going to share my screen now. Hopefully it will work. Hopefully everyone can see that. And we'll get started. So today I'm going to cover some tips and resources for advocating for climate or environmental justice. Just to flag, while a lot of these share the same tactics, some of what I will cover is more applicable for advocating for the environment at your local level, while others are more applicable for advocating for climate action at the national level. So just to bear that in mind as we go through. That's not working now. There we go. So what I'll be covering today is what climate and environmental justice is, and then steps that you can take if you want to advocate for this. So from documenting the issue to collecting information to identifying points of intervention for advocacy and gathering support. So first of all, what is climate and environmental justice? So climate and environmental justice is about all people living and thriving in a safe, healthy, and sustainable environment. It means full protection from climate change and other environmental hazards, and nobody being left behind in climate or environmental action. It is about fair processes and fair outcomes in environmental matters. It requires the just treatment and meaningful involvement of people in decision making that affects where and how they live. So you can see here that it's about having clean, healthy air, protected biodiversity, local accessible services, protection from climate change, safe drinking water, warm, affordable to heat homes, equitable access to green space, no noise pollution, protected and restored water bodies, accessible sustainable transport, equitable access to renewable energy, and meaningful public involvement in environmental decision making. The inequality embedded in our systems, laws, policies, and practices means certain groups and communities face greater exposures to harms like storms, flooding, pollution, energy poverty, biodiversity loss, and dumping. It leads to some groups and communities having less access to benefits like green space, renewable energy, retrofitting schemes, and public travel infrastructure. It also means that many people are excluded from decision-making processes that have an impact on where they call home. However, we all have the right to protection from climate harms, equitable access to environmental benefits, and meaningful participation in environmental decision-making. The groups and communities most at risk of environmental injustices are determined by interacting factors of place, age, and group identity. In Ireland, low-income households, rural and coastal communities, traveller, migrant and minority communities, persons with disabilities, as well as children and older persons, experience heightened exposure to climate and environmental risks and reduced capacity to adapt and recover. This is unjust and it must change. Climate or environmental justice seeks to address this inequality and ensure that action supports people's well-being, health, food security, and overall quality of life. So, what are some steps that you can take to advocate for climate or environmental justice and to protect your rights? The first thing you can do is to document the issue in as much detail as you can. So, documenting information on where the issue is. So, for example, if you notice pollution in your local river, the geographical coordinates of where you can see it, the date and time you've noticed the issue, and a description of the issue accompanied by photos. If there are multiple instances of an issue, you should try to document it over time to show a repeating pattern. You should also gather records of any health effects that might be related to the issue. If applicable, any reports or assessments of the issue carried out by public bodies or consultants, any correspondence between you and the office or body responsible for the issue, and any other information you think might be relevant. So once you've kind of started documenting information about what you're experiencing and kind of collating reports or different records that you have, a next step is to collect more information about the issue itself, its source, and also your rights and the law and policy that might address the issue. So for collecting information about the issue and its possible sources, first see what is in the public domain. So information publicly available can come from official sources such as the Environmental Protection Agency, your local authority, Uisce Éireann, or the Climate Change Advisory Council, for example. So the Environmental Protection Agency collates data on national greenhouse gas emissions and projections. Their most recent projections were published in May 2026 and assesses our compliance or lack thereof with national and EU targets. The EPA also has very good maps that document local environmental information. So this can range from information on waste facilities, air quality monitoring sites, wastewater treatment plants, lake, coastal waters and river quality, protected environmental areas, ecosystem monitoring networks, and industries that have licenses to operate around Ireland. And just an example of this, you can see the EPA map here of bathing water quality in Ireland, with the blue being excellent and green being good. So you can kind of see how these environmental indicators are mapped all over Ireland on the EPA website. And I think Chloe's going to send in the link to access these maps. The EPA also publishes a report on the performance of local authorities on environmental enforcement. This gives local authorities a score and sees how each is performing on their duties around waste, water, air, noise and environmental governance. So this can give a very good snapshot of how your local authority is matching up to others on enforcing your environmental rights. You can also find information about county level environmental data on your local authority website. So information on air quality, water quality, noise pollution and planning data should all be published on your local authority website. And then with the Climate Change Advisory Council, they publish findings and recommendations on Ireland's reduction of greenhouse gas emissions across different sectors. For example, electricity, transport, agriculture, etc. It also looks at how we can increase our adaptation to climate change. So it's worth kind of checking out these more official sources first, but if you can't find what information you want on these, you can also see what else might exist. So there may be reports from environmental organizations. So for example, we published a report with DCU on the key dimensions of environmental and climate injustice experienced by vulnerable communities in Ireland. I think Chloe's going to send that into the chat now. There may also be open source mapping projects. So for example, on the left here, you can see a map that's collated by the Dublin Inquirer. And this documents active travel incidents in Dublin. So hazards, near misses and collisions that people have experienced while they've been cycling or walking around Dublin. And you yourself, if you experience something like this, can go onto the map and add to it. And this is being used by people to advocate for safer, more sustainable transport. There also may be academic studies or articles on the issue you're experiencing. So a quick search on Google Scholar can throw something up in this regard. Just to note that sometimes academic articles are behind a paywall, but I find that if you email the academic, you can either have a chat with them about what's in the article, or they may have copies that they can share, a certain amount of copies they can share with you. So that's another way of kind of getting more information. But what should you do if the information you want is not in the public domain? So the first thing you can do is look to make an access to information on the environment request. So under Article 4 of the Aarhus Convention, which is a UN law that both Ireland and the European Union are signed up to, you have the right to receive environmental information from public authorities. Environmental information produced by a local authority, received by a public authority, or held on behalf of an authority must be made available on request, subject to certain exceptions. A public authority in this regard is any body or organisation that has a role in public administration and possesses environmental information. This includes government departments, local authorities, commercial and non-commercial state entities, regulatory bodies, and bodies performing public administrative functions. Environmental information includes written, visual, oral, and electronic information on the state of the environment, including the atmosphere, air, water, soil, land, landscape, natural sites, and biodiversity. Measures, factors, agreements, policies, legislation, or plans affecting or likely to affect the environment, and public health and safety, where these are affected by the state of the environment. So you can obtain the information the public authority has through an access to information on the environment request. So how do you actually make such a request? So the first step is to identify what public body holds the information you want and their contact details. Once you have this, you can send the request, and it's best to send it in writing, so either via email or a physical letter. And in writing this, you should include your name and contact details, state that you are making an access to environmental information request. That's really important so that they know that the request is being made under this legislative framework. Detail what environmental information is required. Specify the format you would like to receive the information in. So is it, would you like to receive it electronically, in a paper copy, or an in-person viewing? And request the information be provided as soon as possible, and importantly, request a letter of acknowledgement. Keep records of when you sent the request and to whom. A public authority is required to respond to such a request within 1 month of receipt of your request. On or before this deadline, the authority should send you a letter outlining the decision-making process. And there are a number of possible decisions. So either all or some of the documents can be released. Documents are released, but they can be redacted. An additional month is required to fully respond due to the complexity of the request, or the request is refused. There is no initial fee to make an access to information on the environment request. However, a public authority can charge a reasonable fee for the cost of providing the environmental information. Fees can be reduced if evidence of a medical card is provided. Fees may be waived if the cost of supplying the information is estimated to be less than €10, or if the request is not responded or determined within 2 months. If your request for information has either been wholly or partially refused, or you believe it has not been dealt with in accordance with the law, you have a right to seek an internal review of that decision. You may also request an internal review if you have not received a response in the appropriate time frame. An internal review is a complete reconsideration of the matter by a member of the staff of the public authority who may affirm, vary, or nullify the original decision made. Requests for internal review must be made within 1 month of the original decision. Say you submit an internal review and you still haven't got the information you wanted. You can appeal to the Office of the Commissioner for Environmental Information, and more information about this and about making an access to information request is available on our website and the Citizens Information website as well. So just to flag that there is another way of getting information that might not be yet in the public domain, and that's through submitting a parliamentary question. So a parliamentary question is a formal question submitted by a TD or senator for either oral or written response in the Dáil or Seanad. This can be a particularly useful way of getting clarity to find out when a government plan or policy is going to be published, or what government strategy is for addressing a particular issue. Because a TD or senator has to ask the question to the minister, it's best to email them to ask, explaining the information you would like and why and propose kind of certain wording for the question. All answered parliamentary questions are available on the Oireachtas website, and here you can see an example from one last month that Deputy Ciarán Ahern submitted on when the Climate Action Plan 2026 is going to be updated. So it's also a good idea to get more information on the law or policy governing the issue and what your environmental rights are. We have lots of guides on our website on your environmental rights. We have an environmental rights hub, and we also have information guides on topics such as energy poverty, illegal dumping, and the minimum standards of local authority homes. We also did a project last year with the Bohemians Football Club on knowing your environmental rights, and that communicates your environmental rights in a series of comic strips, and that they're available at knowyourenvironmentalrights.ie. There's also the Citizens Information Board website, and then you can look up the law directly in the Irish Statute Book. Just to flag that sometimes if sections of the law have been amended a lot, it can be difficult to follow this on the Irish Statute Book. So it can be easier to look at a consolidated version which kind of looks at all the changes that have been made to the law and put them into one PDF. And these are available if they exist. They don't exist for all laws, but if they do exist, they're available on the Law Reform Commission's website. And of course, if you're still unclear about your environmental rights after consulting these sources, you can, as Justine said, book into one of our free legal information and advice clinics. So you've documented the issue you're experiencing and collected more information on the issue itself and your rights and the law. So the next step in advocating for climate and environmental justice is identifying a point of intervention. So this is where you can influence a decision maker. So you need to identify who the decision maker is and how the decision is made. So decisions are obviously made at different levels. So it could be a case that the local authority is responsible. So local authorities make decisions around land use planning and planning applications at the local level, social housing, roads and active travel infrastructure, environmental protection, and decisions around air, noise, water and waste, and also community development infrastructure. A local authority function is either reserved or executive. So if it's reserved, this means it is made by elected councillors. So a point of intervention could be meeting with your local representative. Local policy decisions are mostly reserved, so they're made by your elected representative. Executive functions then, on the other hand, are the responsibility of the chief executive of a local authority, and they'll be made within the policy framework set by elected members. So corresponding with a section or team under the chief executive could be a point of intervention in this regard if you want to advocate for a particular local issue that you're experiencing around climate or environmental justice. If the decision is one of national policy, it will be made by a relevant government department. They will often have consultations when drafting or updating policy. So one point of intervention could be responding to these consultations. You can see open consultations on a department website. You can also try and contact the minister or department about an issue. Just to flag as well that the Centre for Environmental Justice is a member of Stop Climate Chaos, and each year Stop Climate Chaos hosts a mass lobby where you can go and talk to your TD about climate justice. So that is usually around December of every year, but it's a really great opportunity to kind of sit face to face with TDs or senators and just have a chat about the change you want to see. So that's a good kind of point of intervention that happens annually. Another point of intervention could be when a new law is being made. So a draft of a new law is called a bill, and any member of the Dáil or Seanad can introduce a bill. Government bills are approved by the government before being presented, and before each Dáil term, the government publishes a legislation programme in which you can see government legislation for priority publication and drafting. It's good to keep an eye on this to see what laws can either threaten or progress climate and environmental justice, and if kind of that can represent a point of intervention to advocate for equitable environmental outcomes. So when the government publishes a bill, there's usually a consultation process before this, so a point of intervention can be responding to this consultation. And then on the other hand, opposition members or backbenchers in government parties can also bring forward their own bills, and these are known as private members' bills. Often they're willing to engage with people on these, and so it can be good to advocate for the law you believe will best protect climate or environmental justice by interacting with these opposition members or backbenchers. Both government bills and private member bills may undergo scrutiny by a relevant Oireachtas committee as well. The Oireachtas committee, so we have Oireachtas committees on climate, and we also have them on transport, which may obviously touch areas of climate justice and also agriculture. So the relevant Oireachtas committee may invite stakeholders to participate by attending meetings to discuss the general scheme of the bill, and you can see who is on Oireachtas committee online and contact them to express concern or advocate for a particular point in the pre-legislative scrutiny stage. So then bills also have to go through the Dáil and Seanad debates. So meeting with a TD or senator or advocating for climate justice in this legislative process is a good option for intervention as well. So you've kind of, you've documented the information required, you've collected more information on your rights, and you've identified a point of intervention. It can also be a good next step to gather support. So there's different ways of doing this. It's worth seeing what other people or groups are working on the issue you're concerned about or might be interested in working on it. On our website, we have a manual of environmental justice, and this is created with Environmental Justice Network Ireland, which is based in Belfast. So it's an all-island map of groups doing advocacy around different environmental and climate issues that you may be able to be connected in with. And so the map kind of details how the issue they are working on, broken down into different categories. And if you are part of a group that's not on the map, you can reach out to us and we can add you on that so you can connect with others as well. And on this manual as well, you can also find a directory of academics and climate justice advocates. So that's under the heading Experts Directory to see who you can build power with and campaign with together. So that's a good resource for seeing who else is out there who cares about what you care. And then another way of gathering support is through kind of contacting the media. So local media can be particularly good in this regard. In Dublin, the Dublin Inquirer highlights a lot of local environmental issues, but similarly, many local papers around the country will highlight climate justice advocacy campaigns and will shine a light on what you're working on. So just below you can see two examples. There's one here from the Dublin Inquirer about a case we were supporting out in Darndale, which was a massive illegal dump that residents were campaigning to have the council remove because it was on council land. And the Dublin Inquirer did great coverage of this. And you can also see on the right there an opinion piece from our CEO of Community Law Mediation on changes around judicial reviews that the government were trying to restrict people's access to environmental justice. So that was an opinion piece there. So it's always good to kind of think about what the hook is for your campaign and why people might care, and being able to communicate that through the media is always a good way to try and see who else is out there and to get more information about your campaign into the public sphere. So that's all from me. I hope if anyone has questions that you can type them into the chat. If you want to scan there, you can sign up to our newsletter to get updates on our work. And as Justine said, we are contactable at the info account there and on our website, or you can ring 01847 7804. And Chloe has also sent the link to sign up to our newsletter into the chat as well. But I will stop screen sharing there, and we can see if there's any questions or kind of discussion points that people would like to have a chat through. So we can have a look. So there's a question here, Justine, about the critical infrastructure bill. If you'd like to kind of speak to that and maybe the disapplication of the climate law in that regard.
I'll just speak about this very generally because I haven't been engaged in advocacy on this specifically. So the state has one of the mechanisms in the climate legislation is for public bodies to be under a duty to perform their functions in a manner that is consistent with climate policy. And it was a kind of mainstreaming provision that allowed climate considerations to feature into decision-making by a wide range of bodies. What the state has done in several pieces of legislation now, 3 altogether, has been to disapply this section so that public bodies are not obliged to take climate policy into account in the performance of their functions. It serves 2 purposes, I suppose. On one level, it excludes a grant that could be a basis for legal challenge, but there are many other potential grants. So it strikes me as it's a slightly strange choice to exclude a provision of the climate law in this context, or to portray climate legislation as a barrier, as it has been done, to infrastructure development. Essentially, some of these different pieces of legislation, they're allowing, so critical infrastructure, the designation of certain infrastructure projects as critical. And once this is done, Section 15 is disapplied. It can create some conflicting obligations potentially for bodies that are also governed by European Union obligations. So, for example, if it's a planning authority and it arises in the context of environmental impact assessment that would also consider climate, there have reports before them about climate mitigation and climate impact, but they're at the same time subject to a separate national level disapplication of a duty to have regard to that or act in a manner consistent with it in performance of their functions. So I don't fully understand really what the state is hoping to achieve by this. It's very unclear to me how this will work in practice. I think it's going to be quite difficult for some of these bodies. It gives them very conflicting messages. So I suppose it remains to be seen how this will play out and how many different projects are going to be deemed critical in this way. What kind of projects will they be? So I think there possibly, there are many different concerns that can be raised about this, but one particularly is there's very little in the bill or in the Act now in terms of principles and policies that guide what will be deemed to be critical as well. And I think a lot of these, there's a tendency to sort of centralize power that was once really aspects of decision making that were ordinarily the remit of bodies with specialized experience. So it's a retrograde step on many, many different levels, not just climate. And I'm happy to take any further questions or thoughts that people have about this.
There was one question there as a follow-up, Justine, on how the role of kind of EU law can supplement or where EU law comes in on the disapplication of climate law in relation to the critical infrastructure bill.
Yes, it's interesting. I think possibly there will be the strategic environmental assessment, the environmental impact assessment, habitats directive, those kind of overlaps. There's also potentially, maybe it can be said that our climate legislation is in effect us attempting to implement, and I think you see that in the climate law itself, our international commitments as well as our European commitments. So if we begin to undermine our own climate legislation, then potentially we're undermining the mechanism that we have chosen to apply to actually achieve compliance with our European law obligations as well. So those are the main issues that strike me at first glance, but I think we'll have to see how it works in practice.
Thanks, Justine. There's another question. Sorry, there is a question here on whether slides will be shared, and the answer is yes. The slides will be shared along with a recording with everyone who signed up today, and they'll also be available on our social media and our YouTube channels. There is a question here, Justine, about I guess the cost, access to justice and not being prohibitively expensive in light of Heather Hill and other kind of judgments around that, if you want to speak around any kind of updates on access to justice in that regard.
Yeah, so we have had separately a webinar on this, which is on the cost capping mechanism. It is a very big topic, and the question is a very detailed question. I think it's something that lends itself to, for example, if you want to contact us through the clinic, because there are many different issues raised in that question. But I think overall, the picture that we have is that in Ireland, legal costs are prohibitively expensive and have been for many years. We have extremely high costs of litigation, and we have an environment in which it's quite difficult for people to bring cases, and that is for many reasons. So if you take climate litigation, for example, the complexity of the cases is very high, but due to some legislative provisions, the time frame within which proceedings can be brought is only 8 weeks. So it's extremely difficult for individuals to access the courts, even in a practical sense, of meeting those time requirements, let alone the cost risk. So it is the case that in Ireland we have a no full, no fee regime where lawyers will act for clients, barristers will act pro bono, and they recover their costs only if they win. And it has the effect of, in a sense, a filtering mechanism, because lawyers are only prepared to act in cases where they assess that there is a strong chance of succeeding. Now, what has happened with cost capping is that the costs for the applicant, if they succeed, are capped at a certain level, but not for, say, the state respondent. So the state can pay its own lawyers anything it wishes to, whereas the lawyers for the applicant will face a cap and may potentially say to the client, well, the cap doesn't cover my whole costs, and I would ask you to pay the remainder. And that may have a chilling effect where people will be particularly reluctant to take the risk of having any residual costs. In a litigation context.
Thank you, Justine. Sorry, we're just about out of time, so
Sure.
If anyone wants to have a chat with Justine about that, they can email her. But I just want to be respectful of the 12 o'clock deadline. So thank you all so much for signing up. Really appreciate the work with Bold and being able to collaborate with them on this. I'll just pass over to Maureen to say the final words. But again, if anyone has any outstanding questions that we didn't get to, please feel free to email info@communitylawmediation.ie. Thank you all so much. You're on mute there, Maureen, I think.
I was just thanking Georgina and Justine for excellent inputs there. I just found it amazing in terms of the level of knowledge, and then also from Georgina, just wonderful resources and tips on how to organise ourselves to take climate action. So I suppose I'm just wrapping up by thanking CLM for the opportunity to be involved today, but also to really encourage us all to take climate action. And that can be at individual, community, or national level. But I think what's really important, if we can act collectively, I think it definitely brings an increased strength to what we might try and do, and being, as Georgina said, support, looking around for what other people are doing and working together with others to strengthen our voices, because they're needed now more than ever, as we all know, both with the increasing climate crisis impacts that we're seeing currently over the summer in particular, and also because we are aware, and both presenters have identified problems with at the state and government level in Ireland of backsliding on meeting climate duties and targets. So I'm just encouraging everyone to be engaged wherever you are. And if you want to know more about Bold Climate Action, or you'd like to be on our mailing list, I think our email address is being shared also at the moment, but it's bold.climate.action@gmail.com. So if you'd like to be added to our list, please do send us an email. But thanks to Georgina and Justine and Chloe, who is also doing great work sharing links. So thanks to all of you.
Thanks so much, Maureen. Brilliant call to action to end on. And thank you to everyone who attended today. And we look forward to seeing you at another webinar again. Thanks, everyone. Bye.